Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I'm Senior Associate Ben Hamilton. With me is Associate Attorney Andrew Craven. And if you see us together, that we are here to talk about all things employment-based immigration. And today we're continuing our series on the PERM labor certification process, right? This is the common pathway that people take to go from their work visa to a green card through their employer, through their job offer. Now, this is a complicated process with multiple steps, and that's why we're having to do multiple videos. So we've already done our first video, which is covering the prevailing wage determination, everything you need to know about that. Today, we are going to be talking about the second step in the process, which is the recruitment phase, whereby the employer has to attempt to recruit a willing, qualified, and able U.S. worker for the position before they can then go ahead and sponsor the foreign worker that they want. So, Andrew, how you doing today?
Doing good, Ben. How are you?
I'm doing all right. Ready to talk about recruitment and the many ways that we have seen this get screwed up because it is easy to do. So we're assuming here that the prevailing wage determination, right? We've received that from the Department of Labor where they've selected the job code, they've selected the prevailing wage rate. So does this prevailing wage determination have an expiration date?
Yes. So it's valid for 180 days after it's been certified, it's essentially 6 months.
Do I need to do my entire recruitment within that 6 months?
No, but your recruitment has to start within that 180 days. So within that period, you have to basically get the ball rolling.
So one of the things you're going to learn here is that when it comes to recruitment, there's a lot of timelines and deadlines that have to very carefully be managed. So then second question, okay, that means I have 180 days to start my recruitment. Once I've started it, how long do I have then to file my actual PERM with the Department of Labor?
So then once you've actually started recruitment, another 180-day calendar starts. And within that period, you have to file the PERM after concluding recruitment.
So if you really were to kind of leave this all to the last minute, it could actually be a very long process that takes upwards of a year if you really wait to the last available day to start your recruitment and then the last available day to actually then file your PERM. Again, people get confused. They think I have to do this all within the validity of the prevailing wage determination. It's like, no. You just have to start. Now, we're going to get into why, like, when you're doing your recruitment, you kind of want to do everything at once. You don't want to like do one and then wait a month and then do another and kind of drag it out. That's going to cause problems. But these are some of our first very important timelines. Now, in regards to recruitment, are there any recruitment efforts that are mandatory?
Yes. So first, there's 3 recruitment efforts that apply to all PERM cases, whether they're professional or non-professional positions.
So we don't really care if you are a bricklayer or if you are a doctor and everything in between, right? There's certain things that apply to everybody, with the exception of nurses. Anyway, that's a whole other story. They got their own special carve out. Not doctors, just nurses. So what is the first mandatory recruitment effort that must be done in all labor certifications?
The first one is the state workforce agency. So you have to open up a job order with the SWA or SWA, which is the state labor or employment agency.
So this obviously, then what it's called exactly varies from state to state. What is the SWA for Texas, where we are?
So in Texas, you can find it at workintexas.com.
For how long must the SWA be posted?
So the job order actually has to be posted for at least 30 days, but in the state of Texas, that order actually has to remain posted for at least 33 days because the first 3 days it's only available to veterans, and really the point of this is to make it available to the whole U.S. workforce.
Random question. Is it is it necessarily a bad thing to leave it open for an extra time? Like, oh, I'm going to do 40 days, 50 days.
No, I mean, this is really just the minimum requirements. Ultimately, you leave it open a little bit longer. There's no harm in that.
Yeah. The only consideration to take in when leaving it open longer is that 180 days I have in which to actually conclude my recruitment and then file my perm. You don't want to run into that, right? But if you're starting your SWA, basically day one of your, the first step you're taking is you're filing your SWA, then yeah, you should be fine. Extra days isn't going to hurt you. If anything, we would advise it to just avoid any issues. And I would say that in most part, when it comes to the SWA, I mean, these are done online, and there's fields you have to fill out, and so you kind of and the SWAs work with the Department of Labor. It's pretty much everything that's in that prevailing wage determination is going into that SWA. So we've already talked about requirements regarding language and travel and all that type of stuff. Which great, if it's on the prevailing wage determination, it needs to be in the SWA. What is our second mandatory recruitment effort?
So the second mandatory recruitment effort is placing 2 Sunday ads in a newspaper of general circulation, and those need to be one after the other.
So the first thing is people are going to say Sunday ads in a newspaper. Yeah, these were written like 30 years ago and they haven't been updated in 30 years. So, yep, Sunday ads, which on the one hand sucks because they're really expensive because they charge you by the word. But on the other hand, they're great because who's looking for a job in a Sunday newspaper these days? I mean, if you open up a newspaper on a Sunday, I'm willing to bet that like 50 to 60% of all the job ads that are in there because of this. They're related to H2Bs or H2As or PERMs. They're related to immigration. Anyway, so what paper do I use then? A paper general circulation.
So the Department of Labor has opted not to provide a published list of acceptable publications. So in general, you're supposed to use the best known newspaper in your area. So things like the Dallas Morning News, the Houston Chronicle, LA Times, or New York Times.
Yeah, so in general, go with the biggest paper. Don't try to be like, well, we're in the Dallas Fort Worth area, but we're in Plano, and we'll go with like the Plano Times. It's like, no, I mean, because the Dallas Morning News is bigger and it covers Plano, you have to go with the biggest. Are there any exceptions to the Sunday ad requirement?
Yes, so there's 2. So first, if the work site of the permanent position is in a rural area that does not have a newspaper with a Sunday edition, then the advertisement can run in the edition with just the widest circulation in the area of intended employment.
So again, if we're looking at Texas, this would have to be somewhere where like the Dallas Morning News doesn't reach or the Houston Chronicle doesn't really reach. So it'd have to be pretty rural and pretty outside of one of the major cities for this to count. What if the work site is sort of in a suburban area with so it's like maybe an outer suburb of the Dallas Fort Worth area, like I don't know, Frisco or Prosper, or maybe even up in Salina, which is even farther north.
Yeah, so in suburbs where there's no Sunday edition of the newspaper, then the employer has to publish a Sunday advertisement in the most appropriate city newspaper that serves the suburban area. So if you're talking about like Prosper and Frisco, I'd guess the Dallas Morning News.
Yeah, you're still going to be at the Dallas Morning News for any of those. So you said there's 2 exceptions. What is the second exception?
So one newspaper advertisement can be replaced with an advertisement in a print professional journal if the following conditions are met. So one, the position requires experience with an advanced degree. Two, it would normally be advertised in a professional journal. And 3, a professional journal is the most likely to bring responses from able, willing, qualified, or available U.S. workers. So when we're talking about like more advanced positions, really.
I'm going to be honest. I've almost never seen this. I mean, it's like, why poke the bear? If you can run 2 Sunday ads, just run 2 Sunday ads in the major newspaper. It's kind of one of these things. The second you sort of step outside the box to try to do anything that's nuanced, even when it's technically acceptable, man, it just instantly throws up red flags. It could probably get you audited or increase your likelihood of getting audited. So there is like, you can do it, but why? Why do that? Especially we're gonna get down later as to the additional recruitment methods you may have to take, and you can't use one recruitment method to cover 2 things. You can't say, "Oh, I could do a professional journal, and this professional journal also substitutes the Sunday ad." It's like, no, you can't. You can't have one thing cover 2 bases. Nope, can't do it. So just in general, stick with the 2 Sunday ads in the newspaper. Okay, so what has to go into these ads? Because word count matters, in terms of cost. These things can cost literally thousands of dollars. What needs to go into the print advertisement?
So you definitely have to have the employer's name, provide directions on how to actually apply for the position. Do we email, go online, whatever? Provide a job description that's specific enough to appraise the U.S. worker of the job opportunity for which certification is sought. So basically, you have to provide enough information for the average U.S. worker to actually know what the job is. The geographic area of employment with enough specificity to let them know of travel requirements where the applicant will likely have to reside to perform the opportunity. Also, if the wage is stated, it has to meet or exceed the prevailing wage. You have to include the job duties or requirements that do not exceed those stated in the application. Basically, you can't add extra stuff after you've started this process. And finally, wages or terms and conditions of employment that are at least as favorable as those offered to the foreign national beneficiary.
First thing I would say is if something is not required, just don't put it. Period. Right? Stating the wage is not required, so don't put it because it's too easy to screw it up, especially when you're having to go to, like, let's say a newspaper agency. There's a third party, or sometimes you're using a third. There's companies out there who will handle all this. You'll go to them, say, hey, here's what I need, and they take care of placing all of your ads in all the various places. So there's these other parties, and there's just like, the more people that touch it, the more likely they are to screw up. And why would you want to get dinged because they got a number wrong on the wage? It's like, if it's not required, just don't put it. Like, just don't. But in regards to most of this, I mean, you're going to see the ad. It will say like Microsoft Corporation, Seattle, Washington, software engineer. And then you can take that job description and kind of condense it down into sort of like a 1-sentence description. Because obviously these job descriptions can be long. They can be 15, 20 or lines or more. You don't need to put the full thing, right? You can kind of boil that all down into like, well, what's the 1-sentence description for this job so someone knows what it is. You can, also, like we said, you got to put how to apply. So a lot of times it'll be like, send resumes to HR@Microsoft.com, right? So it's stated how to apply for the job. So again, even though when you look at the prevailing wage, the job description can be something, and all this combined can be something pretty big. That's paragraphs of information. You can usually condense that down into something that's not too bad for a job ad, as opposed to H-2Bs, which have always required. H-2B ads are freaking expensive because there's all this mandatory language and they end up being huge. Whereas the PERM ones, you can get them down to a reasonable size. But again, employer's name, how to apply, location, the general job description, general job requirements all need to be in there. So what is the third mandatory thing that I have to do as part of my recruitment?
So this is where we get to what's called the notice of filing. So the employer has to provide a notice at the work site of the job opportunity and the fact that a labor certification will be filed.
So how long does this notice of filing need to be posted for?
It's going to be for at least 10 days.
Um,
And sorry, to emphasize 10 consecutive business days. So if you're
there you go.
closed on like Saturday and Sunday, then you've got to go through both full work weeks.
When in doubt, it's okay to leave it up a little bit longer, right? You don't want them to come back and be like, well, you left it up for 10 days, but it just so happened that Easter fell during your 10 days. It's like, okay, whatever. We'll leave it up for 2 extra days. Just to be on the safe side. So where do I post this notice of filing?
So it needs to be in a clearly visible and unobstructed and conspicuous place where the employer's U.S. workers can really read the posted notice on their way to and from the place of employment. Basically, this gets posted alongside the other mandatory government postings, things like minimum wage and hours. And this is usually just the break room in the office or factory or what have you.
So where you see all the minimum wage postings from the Department of Labor, any OSHA stuff, I mean, it's basically you put it in the same spot. Um, can it be electronic?
Yes, so it can be published in any and all in-house media, whether that's electronic or printed, as long as it's in accordance with the normal procedures used for recruitment or similar positions in the employer's organization.
So obviously, this thing's going to have some required language. The obvious stuff is going to be, well, the same stuff that's in the prevailing wage determination. What's the employer's name? What's the job duties? All that type of stuff's going to go in there. But what are some of the other maybe not so obvious things that must be in the notice of filing?
So first, it has to state that is being provided as a result of the filing of a permanent labor certification application on behalf of a foreign national worker. So you have to kind of explain why this notice has been put up. Second, it's got to state that any person may provide documentary evidence bearing on the application to the certifying officer of the Department of Labor and include the address of the appropriate certifying officer, which is the National Processing Center in Atlanta. Basically, you got to tell people where they can snitch.
But what I
And
love too is you can tell them where they can snitch, but in order to snitch, they have to mail a letter. Again,
still
this
have
is
to
30
go
years ago. I
back to
can't
the
put
90s or 80s.
it's not an email address. Like, seriously? No, I got to put the address. And you're like, okay, well, I got to go write a letter out, find stamps. I mean, the other day my mom asked me, like, hey, do you have any stamps? And I'm like, what? Why? why? Why would I have stamps? Anyway, so yeah, so the whole snitch thing, which that can get people in trouble, you have to be careful because there has been periods, this was not anytime recent, but there have been periods in which they changed the address or the location to where this had to be, and people didn't realize it. Obviously, we're using a template document where we have a template document that covers everything, and then we obviously just go in and edit it based on the specific employer job requirements, and then we send it to the employer, right? Well, if you're not paying attention, you realize, oh, they changed the address. And so I send the notice of filing and it has the wrong snitch line on it. You can end up getting denied for something that, minor. So it is always important to double check that.
Yeah, I think we mentioned it in some other videos, but you always double check the address before you mail anything in or print anything that has the standard address because they will just change it and not let you know.
USCIS is terrible about, again, this is coming back to how in the hell are we not filing things online, right? Because the Department of Labor, at least I don't have to worry about sending the actual application to the wrong location because we do them online. Great. USCIS, almost nothing's filed online, and they're constantly changing the addresses. So it's really easy to just miss a change and send it to the wrong address, get it rejected. I mean, it's a nightmare. It's like, how are we not filing things online yet? Luckily, the Department of Labor, the only place you can get tripped up on is the snitch address. Whereas when it comes to actually filing your prevailing wage and filing your PERM, those are done online. So you can't necessarily screw up the location there. Anyway, what's the last kind of set of stuff that has to go into the notice of filing?
So the last thing is that it must state the remuneration offered. Basically, you got to say the wage, information about the job that is required in the print advertisement, the employer's name, provide directions to the applicants, whether to report to or send resumes to the employer, and the state worksite location.
So we essentially have a template document that covers all the required language, and then we just fill in the information from the prevailing wage determination in terms of, location, job title, job duties, job requirements, the salary. Um, we just add that all in. It's a template document, so you can't really screw it up. And then at the bottom, there's a spot for the employer to sign, and they also write in the date they put it up and then the date they took it down. Because remember, when it comes to PERM, everything has to be documented. Going to re-emphasize this when it comes to all of this stuff. When you do your state workforce agency ad, you get screenshots of the day it goes up, and then you get screenshots of the day it goes down. Like if it has that embedded date in the website, so you can prove if question the date it went up, the date it went down. Same thing for the notice of filing, that they write the date, they put it up, they put it down, sign it, and then everything. The Sunday ads, right? Obviously, we get copies of the tear sheets to show the date, a copy of the ad, and then the date it went up and went down. All of this needs to be documented. As you're going through the process, we build what's called an audit file, right, where we go collecting all the data, including from the employee, like their degrees and transcripts, academic evaluations, employment verification letters. Like all of this is going into an audit file as we're going through the process. All right, so the mandatory things we have to do are the SWA 30 days plus, the 2 Sunday ads, the notice of filing 10 days plus. And again, these could all kind of start at the same time. Now, there are supplemental forms of recruitment. Who is required to engage in the supplemental forms of recruitment?
The people that are required to are labor certification applications for professional positions.
So that's kind of there's a little bit of well, is it professional? Is it not professional? We tend to defer to the Department of Labor and the guidance from the Occupational Outlook Handbook. But in general, if it's a professional position, and again, that comes back to prevailing wage determination. What are you requiring for the position? Did you try to get this person an H prior? Then of course, yeah, it's professional. But anyway, if it is a professional position, you require additional forms of recruitment. So how many are there to choose from, and how many do I actually have to do?
So there are 10 options, and you have to do 3.
All right, so 3 of 10. So let's kind of run through these 10 options. So what is option number 1?
You can just post it on the employer's website.
That one's pretty straightforward, and for the employer, the great thing is it's cheap. It doesn't cost them anything. Again, it's all about we sending them the ad copy and the employer using that, because can't emphasize enough. Some employers just drive you nuts because they're like, "Oh no, don't worry, we got this." And it's like, no. You cannot just do whatever you normally do, right? This has to be extremely precise. You can't just put up, "Oh, this is our internal job description." No. You need to put what's in the prevailing wage determination. So sometimes you have to get kind of difficult with the employer to be like, "No, this has to be done a certain way. Here is the ad copy. You use this." And then, of course, you want to get confirmation that they put it up, and then you want to go double check it, that you can actually find it and that it's correct. And then again, you get screenshots with the date stamp from the day it went up and the day it went down. What's our second option?
So second, you can post the job on a job search website. So Monster, Career Builder, LinkedIn, Indeed, Glassdoor, one of these.
Now, there is one that we use. It is accepted, and it is not very well known. We're not going to tell you what it is because we don't need to drive more traffic. This is the kind of catch-22 of, I want to use an acceptable form of recruitment, right? That qualifies, that follows all of the rules and regulations, but at the same time, I want the least amount of eyeballs to actually see this thing, right? Because at the end of the day, I'm doing this PERM labor certification not because I'm actually trying to hire a new employee working for me, probably on an H-1B, maybe a TN, and I want to keep them. I want to sponsor them permanently. So ideally, I want to follow all the rules, but I also don't want 500 applicants, because the more applicants I have, the more likely there is one that is qualified, and then I can't go through with the process. So the idea is so when an employer comes back and they're like, "Oh yeah, don't worry, we have an account on Indeed and Career Builder. We post everything there." You're like, "Do you really want to post it there?" Because we get tons of applicants, and it's like you're not getting it. You don't want tons of applicants. We use ZipRecruiter, and they post it to like 10 different websites. It's like, no, don't use ZipRecruiter. So again, you want to comply with the law. You have to comply with the law, period. But at the same time, if I can pick a website that's going to get less traffic, I want to pick the one that's going to get less traffic, because I really want to keep this guy that I have on an H-1B and keep him permanently. Okay, so number 3, what is our third form of recruitment we can use?
This one's actually a little more fun. The employer can utilize an employee referral program with incentives.
So this is one that like sounds kind of obvious, but I feel like there's some pitfalls here. Like, oh, well, I can just say, well, I have an incentive program, like just in general, right? But is it that easy, or are there some additional requirements for this one?
So there are 3 additional requirements. So one, the employee referral program offers incentives to employees for referral of candidates. So you can't just like, oh, we encourage it. There actually has to be some sort of incentive, or sorry, they have to regularly offer this. The employee referral program was in effect during the recruitment effort, and the employer is relying on to support the labor certification application. And then finally, the employer's employees were on notice of the job opening and issue.
So this is where it becomes tricky. We found the best way to do this is that we have that notice of filing templated document. We fill in the blanks, then they go put it on their little break room board, right? Well, if you're going to do the incentive program one, the incentive program has to have already been in effect, right? It has to be something that's been there. You can't just sort of drum it up for the purposes of this and then get rid of it the second you're done. But what we do is we prepare a second document, right, about hey, this position is available for the program. Here's the details of the program, blah, 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 blah. And then they go post that on the board right next to the notice of filing. And then they sign it and they date it, the date they put it up, the date they put it down. That way it's unequivocal, right, that the employees were essentially on notice that this program was available, and then B, that the program applied to this specific position. Again, you don't ever want to leave it up to the Department of Labor to try to figure it out. You want to make it clear as day. When we have a couple of employers we do this with, and they end up again with something that's all filled out that they essentially post right next to the notice of filing, so that there's no questions that they're all related, and then B, we actually have a document evidence. Because otherwise, you have an employer that just wants to point to, well, we have this generalized program that's been in existence for years. You say, well, yeah, but what's the evidence that the employees were aware of it, that they know it related to this position? Like, they can create too much doubt there. If you give any doubt to the Department of Labor, they're going to screw you over. All right. So what is our fourth potential option here?
So the fourth option is that the employer can place an ad with a trade or professional organization, which can appear in a publication, including websites or electronic journals.
Like we said, this is something that's fairly common, but remember, you can substitute one of the Sunday ads for a professional organization if it meets the requirements. But again, you can't double dip here. So if you're going to use a trade or professional thing as one of your supplemental forms, then you just need to do 2 regular Sunday ads. Don't ever try to double dip on your recruitment. The Department of Labor is not going to like it. What is our fifth option?
So the employer can just hire a private recruiting firm.
I almost never see anyone do this for a perm position, if anything, because it's just like it's expensive. And I mean, they get paid by the number of people they send towards you. So they're incentivized to send you as many people as possible, which is not really what we want. So this is not one I see very often. What's our sixth option?
So they can place an ad with a local or ethnic newspaper. Typically, this is the largest local or alternative newspaper that's not used for that mandatory Sunday ad. Again, like you're saying, like no double dipping.
Yeah, so this is where you're like, well, we're located in Plano, which is, part of the Dallas Fort Worth, and there's actually a lot of corporate headquarters in Plano. And they say, well, we're in Plano, so for our Sunday ads, we're going to use the Dallas Morning News because that's the largest circulation in the area. But for a supplemental one, we're going to use the Plano Times or whatever the more localized newspaper is. The one thing they don't want you to do is to be like, oh, hey, when you go to the bus station, there's those little green pieces of paper that are have like job ads and want ads and stuff in it. Like those are not going to qualify, right? It has to be something a little bit bigger than that. And again, this is more like if you're living in a large metro area, like, hey, I'm in Los Angeles, right? But there's like, I don't know, the San Fernando Valley Times or the Long Beach Times, something that's, and I'm located in Long Beach. So again, I'd use the LA Times for my Sunday ads and then like the Long Beach Times for like my supplemental recruitment. What is our seventh option?
So number 7 is radio or television ads.
I don't know if I've ever seen a PERM TV ad. I don't know if they even exist. It'd be really expensive. Radio ads, on the other hand, we use all the time because they're not too expensive. They qualify, and I'm kind of willing to bet they produce absolutely zero applicants because, who's whipping out their pen to really quickly write down, the information from a radio. Hey, look, it's allowed. So we use it, and we use it correctly. So I would say radio ad is actually one that's fairly common. It does cost money, but it's not like super expensive to do. Now, obviously, we go through an agency and they give us a printout with the invoice, and it's the station, and it says the exact date it aired, and it has a copy of the ad print of what was read. So we have document evidence of exactly what the ad was, station, date, all of that. What is our eighth option here?
So 8, the employer can actually advertise at a job fair as long as that fair has some relation to the job duties and requirements.
So you're not going to be like, I don't know, at Comic-Con trying to say, oh, hey, we were recruiting, unless, I don't know, your job was for like a comic book writer or artist, and maybe, I don't know. For me, where this really is like the most common is anytime you're working with school districts who are doing H's and PERMs for teachers, because they have job fairs that are specifically aimed at, the teachers in the teaching profession. That's where I tend to see job fairs come up the most often, is in relation to teachers. But again, if there's like some tech job fair and it's a tech job, hypothetically, you can do that. Now, the problem is these job fairs are big events that have very specific times, and getting them to line up with your recruitment period can be difficult, right? Because you're like, well, I only have 180 days, and we're going to talk about there's a quiet period that goes into that 180 days, and it may be sometimes hard to find something that lines up. Unless, again, let's say you're like a school district and you have teachers and you have very specific times when you hire every year because of the school year. There's also very specific times every year when they do these job fairs. And so you're actually able to just kind of plan your recruitment around that to know, oh, okay, well, we're going to start our recruitment for all of our teachers in this month because it's all going to line up. Then you can make it work. So what is number 9?
So number 9 is on-campus recruiting.
This one can sometimes be a little bit tricky just because if your position requires experience and you're recruiting amongst recent college graduates, the Department of Labor may look at that as not being done in very good faith, right? So it kind of depends on the position. It also depends on whether or not the way you're recruiting involves alumni and not just students. So you do have to be careful there, right? Because you're saying this requires 3 years of experience, and the way it's being done is the only people you're going to run into are like current students who are about to graduate. They're going to be like, this wasn't good faith because there's like no expectation that these people would have 3 years of experience. What's our last option, number 10?
So finally, the employer can place an ad with a campus job placement office.
That one's a it's similar to the on campus, but less problematic because those ones do tend to include alumni. So there's less likely to be any pushback that wasn't a good faith effort. Now I'm going to look at these 10 options and say, in our experience, the most common ones we see are employer's website, job search website, employee referral program, radio ad, and a local or ethnic newspaper. I would say those 5, our experience, are the most common, some mixture of those 5. I guess we sometimes see like a professional trade organization, but I would say our 3 tend to be a mixture of those 5. We don't really see a lot of like on campus job placement, private recruiting firms. Just don't come up very often. So I did my SWA, I did my 2 Sunday ads, I put up my notice of filing for 10 days, I ran my 3 other methods of recruitment. Are there any other things I need to consider in terms of what needs to be done in my timelines?
So, like you mentioned earlier, there's what's called the 30-day quiet period. So basically, after you've done all these things, you've done the recruitment, it all has to be completed 30 days before the application is filed.
And remember, I have to file it within 180 days from when I start, right? So the idea being is you don't want to like, well, I'll run a Sunday ad, wait 5 months and run a second Sunday ad. Well, no, you just ran that second Sunday ad in the quiet period, right? Because I'm at, take that 180 days from when I start, subtract 30, and it's like, well, in that back 30, I really shouldn't be running any recruitment. Now, there's an exception in there. You are allowed to run one of your 3 supplemental recruitments in the quiet period. But the idea with the quiet period is you need to allow time for applications to come in. I want to get everything done, and then I just got to sit back and give people the opportunity to actually apply for the job, and for us to also then consider and, if need be, interview those people. So again, that's why you really want to line up all your recruitment such that once you start, you just knock it all out. And so, if we're saying, well, what's the quickest I can get my recruitment done? I guess it would technically be 30-ish days, because that's the SWA, right? If I start the SWA and everything else at the same time, those other things will be done first, right? Because they're 10 days, 2 weeks, whatever. So you're looking at the quickest I can get all this done is about 33 days if you're in Texas, and then the additional quiet period. So what's the fastest I could do my recruitment, file my PERM? You're looking at 65 to 70 days really is kind of the quickest you could get it done. So, okay, well, I ran all my ads. I'm now in my quiet period, but obviously I'm going to get applications. So what do I do?
So the important thing here is that the employer must undertake a good faith recruitment effort, which entails ensuring that the job opportunity truly was open to U.S. workers. And then on top of that, ensuring that the U.S. applicants that were rejected are rejected for lawful job related reasons.
One of the things we have to remember is that, the prevailing wage and all of that sets up those minimum requirements. So one of the first things you have to remember is I can't then go out of my way to somehow curb applications or 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 discourage people from applying. I mean, that's why usually you just put send resumes to, and all the people do is just they send a resume in order to apply. If you start putting any sort of filters in there in terms of, oh, well, you got to like fill out all this and you got to do that and you got to send this in order to even apply, the DL could come back and say that's not a good faith effort, right? You made it too restrictive. So obviously, in most cases, you're going to be getting a bunch of resumes. Is it possible to reject an applicant based solely on the resume I received?
Yes, if it is clear from the resume that the applicant does not meet one of the core requirements for the position. For example, they don't have the required degree.
And yeah, and it has to be fairly obvious. For example, if there's a language requirement and they say in their application they don't speak the language. That's pretty straightforward. But if there's a language requirement and their application says nothing about languages, then it's like, okay, well, there's some doubt. So what if there is doubt? What if it is unclear? Like I'm looking at their experience and I'm not sure if it lines up, or they have a degree and I'm like, is it related or not? Like if there's any doubt as to when I'm looking at the resume, what do I do?
So the DOL has said that where an applicant's resume raises a reasonable possibility that they are qualified for the job, then the employer bears the burden of further investigating the applicant's credentials. So when in doubt, you got to contact them and start working on some kind of a interview.
When in doubt, interview. When in doubt, interview. Because the Department of Labor takes the most restrictive view possible, right? I love when you're applying for like an H and the USCIS is trying so hard to say you don't qualify, right? Then you get the PERM and it's flipped on you. The Department of Labor is like, well, I think that's related. And you're like, dude, I'm doing this for like, an IT specialist, and this guy worked at a restaurant. Well, yeah, but the restaurant had a computer, right? They had an iPad that they were tapping on to make the sales. That seems related. I mean, seriously, like, so when in doubt, contact the applicant, right? Unless it's just clear from its face, like this, I need a degree in IT, and the resume says I do not have a degree, right? And then you're just like, okay, later, buddy. Or it's like, this is an IT position, and the guy's experience is as a forklift driver. And you're like, okay, I'm pretty sure I can disqualify this guy. He has no IT experience. But if there is any doubt whatsoever, contact the applicant. Can I reject an applicant for them being overqualified? Like, let's say I'm hiring a taxi driver and the guy applying has a law degree.
So no, again, like all this is really about the minimum qualification. So can the U.S. worker perform the job, meet all the basic requirements? And if they can, then it doesn't matter that, they're a taxi driver with a PhD.
Now, if you've ever filled out a job application, you know that sometimes it does ask for like, hey, what are your salary expectations? And sometimes people put their salary expectations on a resume. So let's say my sort of prevailing wage is like $70,000 and I see that their salary expectation is $90,000, right? Can I use that to just disqualify them? Oh, they're asking for more than I'm willing to offer.
No, so kind of those initial negotiations, that doesn't matter. If the applicant is otherwise qualified for the position offered, then they have to be the one to reject it. They basically have to sit here and say, you're not going to pay me enough, I'm out. And then they've rejected the position.
It's kind of like, you have that person you want to break up with, but you don't want to break up with them. So you're trying to get them to break up with you, right? So they have to break up with you. They have to say, you have to interview them and say, well, we're only offering 70. They say, we want 90. And you say, well, sorry, it's only 70. And then they say, no, thank you. Right. They rejected you, but you can't reject them, right? Because you don't know. Maybe they were willing to take less. Maybe they're just highballing you and whatnot. They need to reject you. So we've already determined that if there is any doubt, you need to contact the applicant. How quickly do I need to contact the applicant?
Smart move as soon as possible, because ultimately the Department of Labor can negatively construe any delays. Basically, yeah, maybe you were just trying to wait the guy out, something like that. The current standard is contact within 14 days. So basically, get to him within 2 weeks, but really as soon as possible.
Yeah, because anything over that, they could say, well, you didn't engage in good faith efforts. Maybe you were just trying to like slow walk this, hoping that they would find another job. And then when you did contact them, they just be like, oh, so yeah, no, thanks. I already got another job. It's like, no, you have to contact them within a reasonable amount of time. But here's the other one, the big one that we probably run into a lot is, what if I can't get a hold of them? They send me the resume and I email them, I call them. What if I can't get a hold of the applicant?
Then it's important to make multiple attempts and to document each attempt. So the best example would be like do an email, do certified mail. But like we kind of mentioned before, all this going into an audit file. So you want to thoroughly document that you made every reasonable attempt to contact this person.
Multiple attempts. You're not just going to be like, well, I emailed them, he didn't respond. Department of Labor is going to be like, again, when you're dealing with USCIS, they're looking for every way to like say you don't qualify. And here they're looking for every way to be like, well, just an email? You didn't call them? You didn't send them a letter? And I love the whole certified mail thing because it's like, I got to say, okay, the number one way that I can So usually what we say is call and email multiple times. Keep a record of each one. Obviously, the email is easy. You can print it out. Call, keep a record of it. And then at the very end, when you've tried multiple times and can't find them, send a certified letter, which is ironic because it's like, who would do it? When would you send a certified letter to a potential applicant? I mean, never. Plus, that could force them to actually have to go to the post office to pick it up, and they're not going to want to do it if it's a job they're not interested in. So it's like you're all suddenly putting a burden on the U.S. applicant. I don't know. It's kind of weird, but it is what we have to do. So make multiple attempts, document each one, and then we can say, hey, we tried, but I guess they weren't interested. Now, I did get a hold of the applicant, and we're setting up an interview. Does the interview have to be in person?
No, so it can be over the phone or a video call, just any way that the interview works.
Here's another interesting question. Can the employee who I'm actually trying to sponsor be involved in any of this?
Absolutely not. Basically, once the employee that you need to sponsor has given you their information, they need to be as far away from this process as possible.
Which this can create an issue because we've done perms for like, I don't know, the HR manager. And in that case, they need to be removed from this process, someone else within the company. And it is possible to like hire a third party and designate them as your representative for the process if need be. Like we can see that in cases where there's it's a smaller company, right? And there's a relationship between the employee and the owner, like a family, which you have to disclose if there is, right? And so in that case, you'd be like, well, I'm a small company. I'm the owner. I normally handle like hiring, but because the person is like my cousin, we hired an external HR agency to handle all this process so that the owner, was removed from it. So just be careful there. All right. So when is it lawful to reject an applicant?
So, rejection of a U.S. applicant is lawful only when it's due to a job-related reason. So things like being unqualified, unwilling, or unavailable.
Yeah, again, unqualified is they don't have the degree, they don't have the experience. Unwilling is they reject you. Hey, I know I already took another job, or hey, that salary's not high enough, or of course, unavailable is they just don't respond, they don't show up. What are some other lawful reasons that you could potentially reject someone for?
So, Department of Labor guidance has indicated that bad work references, poor health, lack of proficiency in the English language may be lawful job related reasons for rejection, just as long as these factors adversely affect the applicant's ability to satisfactorily perform the job. So, basically, anything that's just reasonably going to keep you from doing the job right.
In one of these comes up as language, right? Because you get applicants that like apply for the job that don't speak English. They may speak, Spanish, and of course, if they're like, "Hey, I'm applying for this construction job," oh, but the guy doesn't speak English. And you're like, "Yeah, but none of the dudes that are on the crew speak English either." So, you kind of run into this weird situation where, like, if you require a language, you have to justify it. But if you reject them because English isn't their first language, you may also have to like justify it. So when is a U.S. worker considered able and qualified? Kind of what's the definition there?
So they're able and qualified for the job opportunity if the worker by education, training, experience, or a combination is able to perform the normally accepted manner the duties involved in the occupation is customarily performed by other U.S. workers. A U.S. worker can be considered able and qualified for the position if they can acquire the skills necessary to perform the duties involved in the occupation during the period of on-the-job training.
And again, that's one of those ones that we really should have worked out at when we did the prevailing wage as to whether this is a true requirement or whether they can be trained to do this. So you have to be sort of careful there. On the job training, is typically something like, 6 months or less. If it's something that was like over a year, then they would not consider that as reasonable to learn. In our case, I would say that the majority of cases, it's usually either directly related to the because most positions we're doing are professional positions, right? So it's either education, experience, or they couldn't get a hold of them, or the U.S. worker said no. But I mean, but what happens if at the end of the day I find someone that is fully qualified, fully able, fully willing? What happens?
I mean, at that point, everything stops. So, I mean, if you have someone who's willing to take the job, they're willing to accept it, the salary requirements fully qualified, then you're done because ultimately you have found a U.S. worker that
I either
qualifies.
hire them or I shut the process down. But the ironic thing here again is, well, why wouldn't you hire him? Isn't this the guy you want? No, because remember, I'm not doing this to actually try to find somebody. I'm doing this in order to keep the guy that already works for me, because in 90% of the cases, right, that position is already filled. There's already someone working there. I already have someone on H-1B, TN, whatever the status may be, already work. That's why this whole thing is like, I see the logic behind the labor certification. Right. We don't want to hurt U.S. workers, but at the same time, just a lot of the way this thing's administered has just become increasingly, well, um, just kind of stupid in terms of its actual impacts. Now, at the end of the day, we said, hey, we're collecting all the documentation to back all of this up in our audit file. We also have to, well, I guess the thing is how does the employer, what are they required to do in order to document the recruitment steps?
They got to put together what's called a recruitment report. And this report has to be signed by either the employer or the employer's representative. And it's got to include four things, basically. So, first off, is a description of the recruitment steps undertaken. So, you have to describe everything that got posted, the radio ads, all of that. Two, it's got to have a summary of the results achieved, which is the number of applicants, hired or offered employment. Three, a summary of the number of U.S. workers rejected. And it's got to include the lawful job related reason for that rejection. And if it's applicable, the number of applicants rejected in each category.
Yeah, so it's it's a fairly detailed report of, hey, here's all the steps we took, here's all the people that applied. And you want to be fairly detailed in terms of, like, our recruitment reports, in terms of who applied, did you receive a resume, did you attempt to contact them? Then if you did, obviously, why were they rejected? Was it something based on the resume, or did you contact them? You want to you put all you want to you have all these documents, but you want to summarize them all in this recruitment report. It's actually required by law. Now, here's the weird question. We talk about keeping a record of all this stuff at the audit file, generating a recruitment report. Am I actually submitting this to the DOL when I submit my PERM?
Not when you submit your PERM, but if you are audited, then you have to have all of these records.
That's the weird thing, is we're building this audit file, but we only actually end up using it in like 10% of cases, because when you fill out your PERM, it's done online. And when it comes to your recruitment, right, there's this fields where it says, did you run, what date did you run your first Sunday ad? What newspaper? What date did you run your second end? What newspaper? Hey, when did you start and end your SWA? Okay, select the additional recruitment method. When did you do it? Like, you're just kind of filling it in, and then you submit your PERM. And only, a small percentage of PERMs get audited. So the likelihood of them seeing this stuff is pretty low. But of course, if you do get audited, you absolutely have to have it. So that's why the standard practice is that you just build an audit file as you're doing this, and you just keep it there so you have a record no matter what. You don't want to get lazy and then get audited and then realize, oh crap, we didn't have copies of this stuff and we're trying to dig it up. And it's like, no. Do it the right way. Keep a detailed record of everything you're doing as you're going through the process. Build your audit file. Then if DOL comes at you, right, you're ready just to respond with no issues. Last thing I want to say about this in general is, again, to emphasize, PERM is unforgiving. The system was built to be quick. Hey, you do it online, you fill it out quick. And that's what the justification they do for it being unforgivable. To say, well, you just denied me on the stupidest of technicalities. Just saying, it doesn't matter the PERM system was, it was built to be quick. And if you get denied, you can just refile. You're saying, well, great. The problem is in practice, this process, the prevailing wage takes 6 months, or 5 to 6 months. The recruitment can take another couple of months, and then another 5 to 6 months to file my PERM. We're talking over a year to then get denied on a technicality. It's ridiculous, but it's the current system we live with. No errors are allowed. It's not like USCIS. I screw something up, they send a request for evidence. I can correct something. I can supplement the record. With the Department of Labor and the PERM process, there are no fixes. There are no oopsies. I mean, there are some very limited circumstances, but in general, no. This has to be done right, or you will get denied, right? And it can be denied on the smallest of technicalities. It can be like, oh, and one of your Sunday ads forgot to list the location. One said Seattle, the other one, I don't know, for whatever reason, it wasn't there. But it was in this SWA, it was in everything else. Doesn't matter. Denied. Whole thing gone, right? Because of one tiny technical mistake. So the only thing I can say is that if you are someone watching this who you are interested in doing the PERM process, you're the employer or maybe the employee, obviously hire an attorney who is specifically experienced in PERM. Right? Because again, it's so technical. You can find there's plenty of immigration attorneys out there that are great attorneys, but don't know a lot about PERM or don't have experience in PERM. It's highly technical. It's highly specialized. Don't try to do this yourself. It is just way too easy to screw it up. That said, we do have experience in PERM. We do a lot of PERMs, and we're here if you have any questions. So go to our website. You can schedule a consultation, call, email, whatever it may be. We're here to answer any questions. We're here to work with you to walk you through every step of this process. Obviously, we're going to be doing our next video is going to be about the actual PERM labor certification itself, the Form 9089. And then we will have a fourth video about the I-140 ability to pay everything with USCIS, right? So we did a recruitment, we did a prevailing wage video. This is our recruitment video. And then our next one's going to be the actual PERM 9089 video. But hey, thank you for tuning in. Thank you for watching this. Reach out, contact us if you have any questions. Download our app, Lawpilot GUARDIAN. It's a great resource with a lot of useful information there, iOS or Android. But then thank you, and stay tuned for our next video.